Good morning, everyone. Welcome to this employment update. It's great to see so many of you joining us this morning. My name's Jo Oliver. I'm a partner in the employment team at BWV, and I'm going to be joined this morning by my colleague, Alice Reeve. Our session today is about equality, diversity and inclusion in the workplace. This is always a really interesting area for practitioners to talk about. It's always constantly evolving, and at times it can be hard to navigate. Particularly where some rights and protections can sometimes feel like they conflict with one another. So today we're going to explore what EDI means and consider differences between equality and equity. Alice is going to talk you through the current legal framework and changes on the horizon. I'll then look at ways that you can reduce the risk of discrimination claims and practical ways to promote EDI in your workplace. And we'll finish off by looking at staff training. And there'll be some time at the end for some questions, and we'll try our best to get through as many as possible, but there's quite a few of you with us this morning, so we do apologise if we don't get to all of the questions. You can type them in the Q&A box and go through them at the end. So if we go on to the first slide then, please, Harriet. I think it's a good starting point to think about what is equality, diversity and inclusion. And traditionally, this has been about providing equal job opportunities and fairness for staff and job applicants. It's also about ensuring that your workforce is representative of different backgrounds, ethnicities, genders, ages, and looking at being inclusive so that there's a sense of belonging for staff, that staff feel that their views and voices are valued within the workplace. And a positive EDI culture can encourage employee retention, attract the best candidates to your organisation, increase productivity, and it can be important in developing the reputation of your organisation as well. And a diverse workforce means that you have a wide range of talent and experience, and if your environment is inclusive, this is supportive of well-being for your staff and it reduces the risk of employment claims. So it's really important in terms of bedding in the culture of your organisation. And in recent years, we've seen a shift from looking at a focus on equality to thinking a bit more about equity. And this is recognising that treating everyone equally doesn't take into account the fact that some people from different backgrounds may have different disadvantages than others. And it's about looking at levelling the playing field in a way. So equity seeks to provide equality of opportunity by recognising additional resources and opportunities may be needed and allocated to those who are disadvantaged or underrepresented in some way. However, within our current legal framework, this could create some risks for employers, because if you are looking to take positive action in terms of positive discrimination, that can create some liability in relation to those who feel that they're being treated less favourably because of the positive action that's been taken in relation to staff that you're trying to promote in terms of the equity principle. And so it's about finding the right balance between what is lawful positive action and avoiding positive discrimination. So it can be quite a tightrope and quite difficult for some employers to navigate. So with the shift in view from EDI to DEI, looking at equity being about redressing balance and giving additional opportunities and putting additional resources in place, it takes us to looking at what diversity means in that sort of new environment. And diversity has traditionally been about looking at protected characteristics and looking at age, disability, gender reassignment, marriage, civil partnership, pregnancy, discrimination, race, religion and belief, sex and sexual orientation. But diversity is a much broader concept than just those protected characteristics. And so within your organisation, you may want to start looking at things like ensuring that gender identity and social and demographic backgrounds, neurodiversity, are also factored into your policies and the culture that you're embedding around inclusion and diversity. And so if we look in a little bit more detail about what inclusion actually means as well. So traditionally, this has been about respecting and welcoming differences between staff without requiring conformity from everyone to behave in the same way. And recent case law, particularly case law around protected beliefs, so philosophical and religious beliefs, has shown that the threshold for a belief that is worthy of protection is actually much lower than perhaps we have previously thought. And so that some beliefs that could be seen as quite controversial by colleagues, could be seen even as offensive by some, are worthy of protection and protection under the Equality Act, which means when you're looking at inclusivity, recognising that these beliefs exist and including them within your workplace, and making sure that not only are you promoting respect generally when you're looking at inclusion, you're also promoting the idea of tolerance of any minority beliefs and understanding that the protection that those who hold those beliefs have is also important in terms of protecting your organisation from discrimination claims. So I'll hand over now to Alice, who's going to talk a bit more about the current legal framework in place and also some reforms and changes on the horizon.
Thanks ever so much, Jo. It's great to see so many of you here. Yes, it's really interesting to hear about the developments in the language and terminology and the expectations around EDI and particularly equity and inclusivity. But we thought it'd be really helpful to go back and just reflect on the current legal framework, which I think should be at the core of everything that you are thinking about in terms of your EDI principles, even if you then continue to build on it from there. So the current framework is predominantly set out in the Equality Act 2010. You'll probably all be familiar with that. And it prevents discrimination or less favourable treatment on the grounds of particular protected characteristics. You'll be aware that there's a list of protected characteristics. I won't read through them all, but they're there on the slide. From time to time, we see challenges as to whether those protected characteristics should be extended. For example, you'll recently be aware of the debate around whether menopause in itself should be a protected characteristic, rather than being covered perhaps under gender or age, as it is currently. But we've had a fairly level status in relation to that list of protected characteristics at the moment. So the law currently sets out 4 different categories really of discrimination. So Harriet, if you move on to the next slide, we'll look at those different types of discrimination. First type of discrimination is direct discrimination, that someone was treated less favourably directly because of their protected characteristics. So I didn't get a job because I was female. We see conscious direct discrimination probably fairly rarely in our practice, which is a really positive thing. What's becoming perhaps interesting is the increased arguments that people are bringing to say that it's not because of a conscious decision, but it is that subconscious reason, that subconscious bias that has created direct discrimination. But we've seen a number of cases, and I'm currently running a case where somebody is asserting that an employer's decision was subconsciously on the grounds of their ethnicity. So we do see that, and it can be quite difficult to defend yourself against those claims. I think you just need to think about actually always considering why decisions are being made and keeping an audit trail for those decisions, and having a check and a balance to make sure that people are being treated equally and for reasons that don't relate to those protected characteristics. As we note here on the slide, some of the other challenges that broaden out this direct discrimination are that protection can apply not only because of someone's personal protected characteristics, but if there's a perception of them. So that happens, I suppose, most commonly in terms of sexual orientation. It doesn't actually matter what someone's sexual orientation is if they've been discriminated against because of their perceived sexual orientation. They'll be protected under the Equality Act. There are also areas where someone's protected because of their association with somebody who's got a protected characteristic. So again, you most commonly see that where somebody's protected because they perhaps have a responsibility for a child who's got a disability, for example, and so if a decision is made that they can't do the job because they'll always be unavailable, that could be direct discrimination because of association on the grounds of disability. So although in some ways direct discrimination is fairly narrow, we've seen a real extension of it over recent years, and you do need to just be a little bit more careful you don't stray into any of those difficult areas. Indirect discrimination is the second category of discrimination, and this is one that sort of pervades all your decision making, your policies, or potentially, and so you definitely need to be aware of it. And as leaders of HR in your organisations, you need to think about how you ensure that policies or provisions that you're putting in place aren't discriminatory, or if they are, that they're justifiable. So indirect discrimination applies where there is a provision, criterion, or practice which puts, a certain group with a particular protected characteristic at a disadvantage compared to others. Sounds incredibly legalistic like that. I think the examples make it more straightforward. The traditional example is women with childcare responsibilities. And we're seeing quite a lot of cases around this at the moment. So if you have a provision requirement that everybody were to work full time, for example, that will be considered to be something which may put women with childcare responsibilities at a disadvantage compared to others. So then you would need to be able to justify that requirement. So justification essentially means that you've got a legitimate reason for it, a clear legitimate aim, and that aim's a proportionate means of achieving that. So for example, using that little example of a woman with childcare responsibilities, actually you may say, well, it's a legitimate aim that we need that person to be available to their colleagues, all the time. They've got a management responsibility. We need them to be able to support and supervise their colleagues, so therefore that's a full-time requirement. That's a legitimate aim. Is it then proportionate? That calls into question things like, well, could they be contactable on their day off? Is there somebody else who's a second in command who could do that role in their absence? And thinking about whether it is proportionate when you consider the needs of the organisation compared to the impact on the individual. As I say, we're seeing, particularly in the area of flexible working requests, we're seeing an increased number of cases, both sort of across our desks, but also in the courts, where individuals are beginning to challenge the flexible working requests that are turned down on those prescribed business grounds, so legitimately under the flexible working regime, but are covered and protected under the indirect discrimination legislation, and challenging employers whether they've got a legitimate aim and whether their decisions are proportionate. So it's definitely a growth area. The next category of discrimination that I just wanted to touch on is harassment. And again, this is a particularly sort of hot topic at the moment. I've put on the slide the definition of harassment, which is unwanted conduct on the grounds of a protected characteristic, which has the purpose or the intention or the effect. And so one of the critical things that people find difficult on the ground and in practice is that someone doesn't need to intentionally harass somebody. And you often find that where you're tackling a grievance or somebody's behaviour that you feel might be inappropriate, they will assert that, well, they didn't mean it, they didn't intend that, but that isn't a defence to a legal harassment claim if that conduct violates the person's dignity or has the effect of creating an intimidating, hostile, degrading, humiliating or offensive environment for them. As long as, so the test is largely subjective, it's in the eye of the person who suffered the treatment, as long as it was reasonable for them to hold that view. And Jo mentioned the sort of tensions that we're seeing in practice, and this is definitely an area where it's ripe for tension. The sort of, well, hold on, we want to have a bit of fun in the workplace, this is political correctness gone mad, and trying to find the right balance for your organisation and ensuring that everybody feels safe in the workplace is really important. And Jo's going to look at some of the ways in which you might achieve that in practice shortly. The fourth category of discrimination I've just included here, really for completeness, is victimisation, and that is essentially where somebody has brought a claim, raised a grievance, acted as a witness in a discrimination complaint. They are then protected from suffering any victimisation, any less favourable treatment or detriment as a result of having been involved in that way. And of course, you would also say, well, we would never do that. It can be really complex when you're dealing with a very difficult case in practice, and particularly if they've brought a series of claims or things that haven't necessarily stood up to scrutiny, but they will still have that protection from victimisation. So you'll just need to be aware of that as well. And finally, just for completeness, I've mentioned the duty to make reasonable adjustments, which I think you'll all be aware of, which is an additional obligation, not only to ensure that people aren't treated less favourably, but to make positive steps to make reasonable adjustments for those with disabilities in the workplace to help them overcome any substantial disadvantage. So that's how the Equality Act works, and it's unlikely that we're going to see any changes. In addition to the Equality Act, the other piece of sort of legal framework that you need to be aware of is the Equality and Human Rights Commission Statutory Code of Practice. Can't believe it's 2011. It seems really old now, but actually this is a legal document that has statutory effect. And so it is worth going back to that from time to time, and it sets out and explains the law in a bit more detail and talks about some of the things that you should be doing to prevent discrimination in the workplace. As I say, Joe's going to talk about some of those in more detail, but for these purposes, it's important to understand that that code can be used in legal proceedings brought under the Equality Act. And so actually, if you breach the code, the burden will be on you as an employer to show that you haven't discriminated against an individual, that there's another reason for their treatment. However, more positively, if you implement the things in the code effectively, that may help you establish a defence to a claim for discrimination or harassment by one of your employees against another employee, where you've shown that you've taken reasonable steps to prevent harassment or discrimination in the workplace. So we're not got time today to go through the detail, but obviously the code talks about things like having a policy and raising awareness and training, and Joe's going to look at that in a little bit more detail. We have also seen developments in the area of sexual harassment in the workplace, and this has been a really growth area, and those of you who've been on these webinars in the past will know that we've touched on this, because in 2020, the Equality and Human Rights Commission issued some technical guidance on sexual harassment in the workplace. As well as that, we've got some ACAS guidance as well. Interestingly, the CIPD did some research back in 2020, and that found that 17% of women still felt that they had been subjected to bullying or sexual harassment at work, which is a really significant percentage when you think about that applied to your organisation. And furthermore, that 24% of all employees felt that their employer would sweep harassment and bullying under the carpet and wouldn't do anything about it. So there is clearly a drive to correct that and to make sure that employers are taking this seriously. So at the moment, the technical guidance isn't a statutory code, so tribunals aren't obliged to take it into account, but it's really a useful document to show that you are meeting best practice and going beyond at the moment your legal obligations. The intention is to ensure that people understand what harassment is in the workplace and the extent and impact of that, and it sets out quite a lot of best practice to essentially both proactively prevent it, as well as responding to it when it arises. So it's a really useful tool for you all to consider the steps that you may want to put in place. We fully expect that at the moment which is non-statutory, will become legally binding, and the government have said that they are committed to turning that into a statutory code of practice. So similar to the code I was mentioning on the previous slide, that will mean that it has legal effect, and breach of it is likely to mean that you're in breach of your legal obligations unless there's a very good reason why not? We're not entirely sure when that's going to happen. It has been on, it has been on the sort of plans for a very long time now, and it would be a relatively easy thing to do because they've already got the technical guidance in place. So I would anticipate that that may happen sooner rather than later. So in the course of this year, possibly, but we haven't got any statutory time frame at the moment for that to happen. And then finally, before passing on to the more practical steps, I've got a couple of slides to talk about a new and developing area that we wanted to bring to your attention. This is a private members bill that's currently going through the parliamentary process. It actually went to the House of Lords, I think, just last week, having gone through all the Commons stages. So again, it's likely to pass into legislation fairly soon, and it's supported by the government. This is a piece of legislation that amends the Equality Act, so it's got a quite complicated name, the Worker Protection Amendment of the Equality Act 2010 bill. The intention behind this is, again, to ensure that everybody at work is safe from harassment in the workplace. And so there is a huge amount of support for this coming into practice. But it has been interesting to look at the debates and to ensure that there's a correct balance between making sure that employers don't have to take too many onerous steps and don't face liability when perhaps something's out of their hands, and how to get the balance right to ensure there's adequate protection for employees. So you're probably already aware that an employer can be treated as liable for the actions of its employees when one employee harasses another employee, unless they've taken reasonable steps to prevent that. One of the main changes brought in by this amendment bill is that an employer will be treated as harassing its employee when a third party harasses one of their employees when they're in the course of their employment, and the employer has failed to take the reasonable steps to prevent that harassment. So just breaking that down a little, that means that essentially where a customer or a client or somebody who engages with one of your employees, could be a volunteer, any third party who engages with one of your employees who's carrying out their job, actually, if they do so in a way that meets that definition of harassment, then you as their employer could be liable for that, unless you've taken all reasonable steps to prevent it happening. Obviously, what are reasonable steps in that context? It's quite different, the controls that you have over your employees, and to say this is the kind of employer we are, and this is the organisation that we are, and this as an employee, these are the rules that you need to abide by, and we don't tolerate this sort of behaviour in our workplace. You can see that it's perhaps more difficult to do that with somebody who might be a customer or supplier of services, and thinking about, say, cafes or restaurants, how far do they need to go to ensure that people who are coming in and using, buying some food aren't subjecting employees to harassment. So I think we will see some further guidance before the bill is introduced, but you will need to think quite carefully around your own practices. It will be more than just not turning a blind eye if something crops up. You will need to take positive steps to prevent harassment. So you'll need to think about what that actually means, whether you need to put things in your terms and conditions of service, whether you need to put signs up, whether you need to have overarching sort of codes of conduct and statements of principle on your website, for example. I think there will be a number of things that you might need to think about doing in order to meet that requirement to take all reasonable steps. There's a really interesting exemption to the general principle, which has been the cause of a fair amount of parliamentary debate, as well as amongst interested employment lawyers, which looks at that general principle and says that there will be sort of an exemption where individuals are expressing an opinion where that's not indecent or grossly offensive, and where the conversational speech involves the expression of an opinion on a political, moral, religious, or social matter. So where people are in a place that happens to be a place of work for others, and they're expressing an opinion that's not in itself grossly offensive, and they're having a discussion around political or religious or social matter. For example, gender critical views, the government's views on things. Those sorts of things are covered, and the harassment isn't intentional. So actually it might have the effect, so when you look at that definition of harassment, it might have the effect of making somebody feel like their dignity is being violated, or they're in an offensive environment. But actually, as long as it doesn't have the purpose, it's not intended to do that, you'll be able to rely on this exemption. And where it's not directly aimed at the employee, and so took place in a conversation which didn't involve the employee, then actually the employer won't be treated as having failed to take all reasonable steps to prevent the harassment, solely because they didn't seek to prevent the expression of that opinion. So that's a very clunky bit of law as drafted in the current bill at the moment. I think we will see a number of revisions to those definitions and how that takes effect, or well, perhaps hope so. The debate is around how you expect an employer, somebody who is operating a service, or to intervene or police conversations that are going on. So, using my example, I suppose, for a cafe or a bar, are the bar staff expected to go around and intervene where people are having a lively debate about something? The answer is no, if it's not grossly offensive and it's talking about a political, moral, religious or social matter, and it isn't directly said to the people working there, so the bar staff, for example. So it's trying to create that balance where people can have some freedom of speech, and where the burden on employers is not too significant, but actually still creating a safe environment. So I think we will see some discussion around that area, but it's certainly an interesting one, and you will need to think about, for your organisation, what that means. And then finally, before I hand over, just wanted to, the final element of this bill. We'll just flick on to the next slide, Harriet. The final element of this bill is that rather than, at the moment, there's a sort of defence to claims of harassment, where if someone were to bring a claim that they've been subjected to harassment in the workplace, that it's a defence if you've taken all reasonable steps to prevent that. This shifts that so that there's a new proactive, positive duty to take all reasonable steps to prevent sexual harassment in the course of employment. So you'll be in breach of the legal requirement if you've not taken all of those reasonable steps to prevent it, even technically if sexual harassment hasn't actually happened, and it's likely that it will be enforceable by the Equality and Human Rights Commission itself. So in practice, that's unlikely to make a significant difference, because we'd be advocating that you should be taking all reasonable steps to prevent sexual harassment in the first place. But it does place an increased importance on it and make it a positive legal obligation. And one of our reasons for continuing to talk about this topic is that actually I think as good employers, you want to be ahead of the curve and think about those things that you might be putting in place and having a plan, so that when we do get this law, you already have got the reasonable steps that are in place, and you're not doing it just because there's a legislation telling you that you should do that. And so if you breach this positive duty and somebody is subjected to harassment, then that can lead to a compensation uplift of up to 25% of what would be their injury to feelings award, or any financial losses flowing as a result, for example, if they've assert constructive unfair dismissal as well. In terms of timeframes, we're likely to see a year's notice of this bill coming into force, because of the discussion around what it actually means for all employers. So at the moment, it's going through the parliamentary process. Notwithstanding the amount of debate on the sort of nuances of it, it has got an amount of support. So I think we will see it passed into legislation certainly this year. And then there's talk of there being a 12-month lead-in period with support with another Equality and Rights Commission statutory code of practice, which will go into more detail in terms of what the expectations on employers are. But it's certainly an interesting area. So having taken you through the legal framework, a lot of this relies on you taking steps to ensure that you've got a working environment where your staff are free from discrimination or harassment. And I'm going to pass over to Jo, who's going to look at what that might mean in practice.
Thanks, Alice. So yes, the next thing we're going to look at is how your organisation can potentially reduce the risk of a successful discrimination claim being brought against you. So the first thing to think about is embedding a positive culture. And we're going to talk about that in more practical terms on the next slide. But essentially, if you provide a workplace that is diverse, that's respectful, is fair, where staff have the ability to raise concerns and those concerns are effectively dealt with, then the risk of those members of staff becoming disenfranchised, becoming aggrieved, raising complaints is going to be less. So from a practical point of view, that's the good starting point to have. In relation to being able to defend a claim, Alice has talked about the all reasonable steps defence. And so this is where an employee has committed an act of discrimination, harassment or victimisation against a colleague in the course of their employment. Their employer isn't necessarily liable for that discrimination if the employer can show that it took all reasonable steps to prevent the discrimination from happening. So that will involve making sure that your organisation has up-to-date policies and procedures in place that deal with issues like anti-harassment, anti-bullying, equal opportunities. And not only do you have those policies, that they're reviewed regularly, they're updated regularly, that the content of those is challenged and is addressed with maybe work committees or staff groups that are tasked with looking at EDI issues. And that there is effective training in relation to those policies. So you want to be able to show that all staff have access to them, have had an opportunity to read and review them, to raise any queries about them, and that they've had training on how to work in practice within the requirements of those policies. And having sufficient training or effective training is really important in making sure that you're setting expectations about the standard of conduct expected of staff and giving practical examples of what discrimination might look like in the workplace. Because I think, as Alice mentioned in her earlier section, it is much more nuanced now. Discrimination isn't overt in a lot of workplaces. It's sort of sitting at an unconscious level, and it's helping through training to get staff to identify potential stereotypes or prejudices that could be manifested in the workplace, and being able to change and monitor their behaviour as a consequence of that. And another point around being able to establish the reasonable steps defence is that as an employer, you would need to make sure that you are dealing with any incidents of discrimination, that it's all well and good having policies in place, training staff, but if a complaint comes in and then you don't deal with it, you're not sending an appropriate message that that behaviour isn't acceptable, and it looks by implication that you're condoning it. And so if you're not taking disciplinary action where it's found on investigation that someone has breached your anti-bullying or harassment policy, for example, then the reasonable steps defence may not be available to you because you're not doing enough within your workplace to stamp out that kind of behaviour, and you're allowing someone who you have found to have potentially committed a discriminatory act to stay and repeat that behaviour in the workplace. And there's some other practical things that you can think about as well in terms of showing the reasonable steps defence. So making sure that staff know how to raise a complaint, making sure that you've got methods in place for them to do that, so that they can report incidents in a safe way and feel comfortable that they can come forward without any reprisal or retaliation. And so that's giving an open culture to come forward to be able to do that. And then it's really important as well, if you were to rely on this defence, to be able to maintain records to evidence what you've done. So being able to show who's done what training and when, what did that training cover, when did you last update your policies, what were the changes you made. So keeping different iterations of your policies to show the development of your thought process around protection and on EDI issues. Making sure that you're tracking complaints that are coming in, looking for themes, thinking about launching initiatives to deal with those themes as well is very important. So if we move on to the next slide, please, Harriet. And we can look in a bit more detail here about embedding that positive EDI culture. So the first thing that I've got on the slide here is about equality monitoring. So it's about identifying issues, identifying those within your workplace who might be underrepresented, those who might be disadvantaged in some way. And once you have that information to hand and you can identify which characteristics, protected characteristics, might be underrepresented or may be struggling in terms of promotion or may not even feature in your workforce, you can then think about setting EDI targets to change that position and move to a more diverse and inclusive workplace. So, for example, you could set targets for greater representation at senior level for women. If you've noticed that at board level, your organisation is predominantly men, or you could have a target that sets up or establishes a mentor programme so that it increases the equality of opportunity for ethnic minorities because they can see a role model or a mentor and that will help address that position. You could also set up internal networking groups. For example, you could have an LGBTQ plus group that encourages allies to support to support the development and promotion and equal opportunity of that particular group. Thinking about having workplace equality champions is another thing that you can do to embed a positive EDI culture. So making sure that you have within your organisation individuals who can advocate for the rights and fair representation of those from different groups and backgrounds, making sure that they are able to report any concerns that they see, monitor any activity, and allow through that level of visibility change to happen within your organisation. And it's helpful for those equality champions to be at different levels within your organisation. So any member of staff feels comfortable coming forward to be able to speak to them, to raise any issues, and for those issues to then be escalated and dealt with. Mentoring is another way of looking at promoting a positive culture. So mentoring can mean that you have role models within the organisation with different protected characteristics that encourage the career development and growth of those people sharing those characteristics, particularly if they are underrepresented currently within the workforce. And also having someone available who isn't maybe their direct line manager to mentor them and to talk them through any challenges is another opportunity to create a positive working environment and a positive working relationship that supports the development of that individual, particularly if that individual comes from a background where they are traditionally underrepresented. And then looking at diversity within recruitment as well. So thinking about the wording of job adverts, making sure that as an organisation you challenge yourself on what that wording says to make it clear that it shouldn't exclude any particular areas of potential workforce. So anyone with a particular protected characteristic, for example. Thinking about the audience of that advert and how it will be perceived by them when they read it, and thinking about the use of wording and the language in that advert too. And making a clear statement when you advertise for a role that the organisation promotes EDI and is committed to doing that as well. And then thinking about where adverts are placed, for example, making sure that there's a wide circulation, that it's not just within a particular publication or with a particular recruiter that may be based in an area with a certain demographic that doesn't extend to all protected characteristics. And making sure if you're using a recruiter that you brief them that you are an EDI employer and that you want to ensure that when they're looking for candidates for you, they're doing that from a wide field. There's also consideration around the need for those who make decisions on recruitment to have had training on EDI issues and unconscious bias, to make sure that they're not making any decisions from a place of unconscious prejudice where they perhaps don't realise that they are stereotyping someone from a particular background, and that they are aware and should challenge themselves on any preconceptions they have about any candidates. And as well, when you draw up a job description, when you're recruiting new staff, it's about thinking about, can you objectively justify the tasks and duties that you're saying that role requires? Are they absolutely necessary to perform that role, or are they nice to haves? And if they're nice to haves, would they exclude certain candidates from thinking that it's a job that they could do or should apply for? And then the final thing on this slide is thinking about up-to-date staff training. So making sure that all staff undergo regular EDI training. And we'll come on to what that training entails and what it should cover in the next slide. So if we move on, please, Harriet. We've got a quick poll first. So within your organisation, do you provide managers with additional training on navigating EDI issues? So if you want to vote, you've got yes, we run specific training for managers, no, managers undertake the same training as everyone else, or we don't currently offer any EDI training. So if you vote now, I'll give everyone a couple of minutes to do that. And if we close that poll, let's see what the outcome is. So interestingly, I think the majority of you say that managers undertake the same training as everyone else. So they don't do a differentiated style of training. They don't do an additional level of training, which is quite interesting. So we'll come on to that in the next slide. You can move on to the next slide, please, Harriet. So staff and manager training needs. I think the thing to think about is that there is a base level of training and understanding that everybody within your organisation needs to have around EDI issues. But for managers, they need to be putting in place or dealing with issues and complaints. So they need to have the skills and feel empowered to be able to address those issues, have sometimes challenging conversations with staff members, know where to escalate issues, know how to engage with HR for help and support. So having additional training for managers is really important in having an effective EDI culture and maintaining that reasonable steps defence as well. So there are different types of training that can be provided, but as a base, you would want to make sure that you have equality and anti-harassment training. You'd want to have that extra level of training for your managers so they feel confident in dealing with EDI issues and that they don't shy away from dealing with them. As Alice mentioned there, the survey where women felt that issues were being brushed under the carpet in the workplace. So it's important to have that level of training that managers are seen to be dealing with those issues. Unconscious bias training, which I've touched on in the area of recruitment. So this can be quite controversial. Maybe controversial isn't the right way to describe it, but there's been different thoughts around unconscious bias and the benefit that this training can have. But I think in collaboration with other training on the legal framework for equality and diversity, looking at anti-harassment, particularly around preventing sexual harassment in the workplace, unconscious bias training still forms a really valuable tool in helping staff identify personal prejudices that they may not have realised that they had and how that could impact the workplace and impact those that they work with. So there's still, I think, a lot of value in unconscious bias training, although it has some conflicting views currently. And then training workplace champions. So we talked about making sure that you had champions in place, and it's making sure that they understand their role, they understand the policies, they understand how to report and escalate issues and how to deal with staff who come to them and how to help and support them. If we go on to the next slide, please, Harriet. So if we look in a little bit more detail about staff and manager training needs, it's important not only that you offer training, but that you do it regularly, and that when you make updates to your policies and procedures, that you think about how that cascades down into your training program too. Having EDI training as part of your staff induction is essential. It's a core pillar of the expectations that you set for staff in the workplace. And so if you're going to rely on the reasonable steps defence at any point, you want to show that all of your staff have had that training, and it helps bed culture in from the beginning when they start implement with you. There was a case a couple of years ago, the case of Ale, where an employment tribunal did review the steps that an employer had taken to try and prevent discrimination in the workplace. And in that case, the employer was saying, we have done everything that we reasonably can. We've done all reasonable steps. We shouldn't be held liable here. But on examination, the tribunal found that the EDI training that staff had taken place 20 months or more before the incident had taken place. So it wasn't fresh, it was considered stale. And that whilst they had policies in place, on the ground, they weren't really being implemented, and the action wasn't being taken against potential perpetrators of harassment. And therefore, on the surface, whilst the employer had the right documents in place, what was happening in practice wasn't enough. And so their attempt to use the all reasonable steps defence failed. And so for you as employers, it's important to take note of those findings in that LA case, and thinking about having regular training. Don't let it go stale, making sure that if there's a problem, it is escalated, it is dealt with, and that you're recording what you did in response to that complaint or issue, and that you've got a safe space for staff who overhear, for example, something that could be considered as harassment, to come forward to say what's happened so that you can address it, and that you're setting those expectations that people will report the wrongdoing of others to show that that is behaviour that's not acceptable in your workplace. And it's really important then to keep records of training so that you can track that it's been done, and making sure that those records show what training was done at what time, so what that training covered, so that if you needed to rely on the reasonable steps defence, you can show that it was a broad breadth of training on the issues, and it also set the expectations that you would want to see from your staff members. So if we move on to the next slide, please, Harriet. Which brings me on to the fact that we have worked on some equality, diversity and inclusion e-learning training. It's coming soon, and it covers a number of the issues that we've talked about today in the training areas. So if you might be interested in potentially signing up to this training, or if it's something that you feel that your organisation might be interested in hearing more of, please do indicate on the poll here. Thank you, Harriet. We've got some time now. We've got maybe about 10 minutes for questions. So if anyone has any questions and haven't put them in the Q&A box, please do.
Fab. Thanks, Jo. One of them is a very nice lead into us asking about the VW Plus training, and can a manager training be added? And yeah, absolutely. We, as Jo said, we are currently reviewing the training and producing some new modules, including one specifically for those with line management responsibility. So thanks for that. Then we've got two other questions in the box. The first one is around symptoms for menopause and the perimenopause, and whether what adjustments you can put in place for that. There's quite a lot of guidance around. The ACAS has produced some guidance. We've got a policy as well, if that's of interest. I mean, the sorts of things you need to think about are, well, training for managers so that they understand the symptoms and what people might be going through, making sure that individuals can raise concerns in a safe way and have those dealt with, thinking about if you've had somebody who's been a good performer for a long time and then they're struggling with their performance, supporting them in that, perhaps rather than going directly into a capability process, the same with periods of absence that may relate to that. Like other reasonable adjustments, you might want to consider time off for medical appointments if they need that. Other things will depend on the symptoms that they are struggling with, but suggestions in the guidance are things like having a quiet room where people can go and take some time out, and having cold water available, making sure that toilets are readily available for them. But it's absolutely around ensuring that you're having a dialogue with individuals who are perhaps struggling with the symptoms, understanding what it is they need, and making sure that they're supported rather than penalised for those in the workplace. Jo, I don't know if you've got any other things that you would add to that.
Not necessarily. I suppose there are sort of the workplace support groups and things like that to make people feel that they are not alone in those issues. So that's one other thing potentially to consider too.
Thanks, Jo. There's a really interesting but quite challenging question that I might throw to you, which is around small organisations and any tips on how you might carry out anonymous but also meaningful monitoring of data and information. I think it is quite hard, that, isn't it, really, the gathering of data and what you actually do with it. I don't know if you've got any thoughts in the first instance.
I suppose I think if you're going to do this as a new exercise, it would be about setting the scene for staff and why you're doing it, so that you get buy-in. Some of the information or some of the questions that might be helpful for you to identify issues may be very personal to the individuals, and they may feel uncomfortable about sharing that level of personal information. So if they are aware of what it is and that it's anonymous and how you're going to use it, then their buy-in to that process hopefully can be obtained. And using things like staff surveys and other mechanisms can be useful in getting that data and thinking then about what you're going to do with it too.
Yeah, I agree. And I think maybe starting with small things first, because I can see that if, for example, you're tracking internal promotions and you have got a small workforce, you might be able to identify people by their job title and by, you know, their particular characteristics. So I suppose it's just thinking around, you know, what you're going to do with it and making sure that you're only capturing data that's going to be used for that purpose in the first instance. And then perhaps also thinking about who has access to that information in that sort of unredacted form, and limiting that. And then when people are making decisions, you know, making sure that perhaps the information is compartmentalized so that you can clearly show that it's not sort of affected decision making, other than where people are looking at trends and kind of the bigger picture of the data rather than individual responses to it. There's a really interesting question around schools and how the obligations to support, to take steps to support, prevent teachers from being subjected to comments by pupils. And absolutely that will fall into this area of protection from third-party harassment in the workplace. And I think we will obviously talk about it more as the law is coming in, but we have seen this in the past, and there have been some cases where, for example, employees will be protected from being subjected to comments by pupils, for example, on their grounds of their gender or their sexual orientation or their transgender status. So, you know, it will be really important to take reasonable steps. Now, what counts as reasonable steps for pupils will be different than what is reasonable steps for staff, because you're an educational organisation. Pupils will be expected to make mistakes but also learn from those, and that can be really difficult. But thinking about what you have in your curriculum, you know, and expanding on that and ensuring that people are treated appropriately. But you will need to think perhaps about, if you're an independent school, what's in your parent contract. If you're a maintained school or an academy, some sort of, you know, statement around your culture and values that you can hold parents to. And then thinking about, and if students, putting them in your behaviour policies as well, and if pupils breach them and or parents breach them, taking active steps to manage those and protect your members of staff. But you will need to do both. You'll need to put steps in practice to stop it happening in the first place, and then also act appropriately in the event that there is an issue or someone complains about it. I can see that it could be a challenging area, and I think we'll all need to think about what that might be. Jo, I don't know if you've got any other thoughts or things you wanted to add.
No, the only thing I was going to talk about was the behaviour policy, and I suppose the difference between, in a school environment, there is an expectation about managing conduct of both staff and pupils, whereas this legislation, where it goes to other third-party harassers who have no contractual relationship or no behaviour policy guidelines in place, can be harder. So I think within a school environment, it's probably easier to police than perhaps other employers.
Yeah, I agree. Although I think there will be a sort of context in terms of what's reasonable, because if you are dealing with, you know, younger children who might say something, you know, as I suppose, without understanding what it is they're saying, you know, I think that will be, there's a different expectation on that as well. I mean, we deal with quite a number of organisations where, you know, they, well, maybe care homes, or, you know, or also special schools where there's not necessarily levels of understanding, and again, you know, how that's taken into account will be interesting as well. I think one of the things, I know we're sort of up against the time now, in the last minute, I think one of the things that's come out in the debates around this is that tension between being able to have a debate in a safe space, and that is different than subjecting somebody to offensive treatment, or treatment they consider offensive. And Jo and I were talking about this, and I think, you know, there will be a balance between, there's a clear message that you should be able to have difficult discussions, and there should be an ability to have freedom of speech, but where, you know, where that is directed at an individual, or where it oversteps the line and it's sort of grossly inappropriate, then you will have to have taken reasonable steps to prevent that. But it's not intended to, you know, it's clear that it's not intended to stop, for example, different speakers coming, or people being able to hold views and even express those views if they do so in a respectful way. Although I don't know if we've answered all the questions. Yeah, I think we have. So we've manage that timing well. Thank you very much for joining us. We really appreciate it. And if you've got any particular questions or scenarios or anything we can help with, please do get in touch with Jo or myself.